Hi class, and welcome to lecture 2 here in Sociology of Law. This lecture is going to be filled with quite a few discussion questions that you'll actually be answering throughout the course of this semester, but it's important that we talk about them a little bit here so that you're more informed in answering them. Also, at the end of this lecture, we'll talk about some of the readings that you'll be responsible for the exam. All right. So the first discussion question that we have here is: it better that 10 guilty persons shall go free than one innocent person suffer? And this is a very interesting discussion question that if this was an in-person class, we would probably spend the vast majority of the class period discussing. Because some people suggest that if you're guilty, it's important that justice is done in the form of convicting you and sending you to prison, whereas other people think a greater injustice is an innocent person actually suffering. And your opinion on that may differ, but basically what this whole discussion comes down to, and that what you guys are going to have to decide, and you will have to take a side on this in your discussion post online, is these conflicting goals of the right of the individual versus the common good or the rights of society as a whole. Now, the law clearly functions to protect both of these rights, right? We protect citizens from crime, of course. We don't want bad guys coming after us, but we also need to protect the accused from an unfair trial, right? We have these amendments to the Constitution that say, no, you get the right to a fair trial. You get the right to an attorney, because we don't want people being convicted for a crime they didn't commit. However, these rights are conflicting in that what's best for the individual, or seems a logical right for the individual, isn't always the best for society, right? And through time, the tension between these two rights is illustrated in a lot of different legal decisions, right? For example, we have Miranda rights, that we have to tell people, even if we saw them commit a crime, that they have the right to remain silent and they have the right to an attorney. A lot of people, that drives them crazy. No, we shouldn't tell them they have these rights. Or the exclusionary rule, right? If there's an illegal search of your house with the Fourth Amendment, and the police search your house illegally, any evidence they find against you gets thrown out and can't be used at trial. That drives people nuts, because people say they get off on a quote-unquote technicality, right? And so there are a couple models of criminal justice that are shown in these different rights, right? There's the due process model and the crime control model. The due process model places the primary value on the protection of citizens from possible abuses by the police and law enforcement systems generally, right? This assumes suspects are innocent. The burden of proof rests on the prosecution, not the defense. The due process model, as you hopefully learned in intro, makes it as difficult as possible to secure a conviction, because the rights of the individual are the most important rights there are. Now contrast that with the crime control model. The crime control model seeks the punishment of lawbreakers, emphasizing the efficient detention of suspects and prosecution of defendants so that the society can be assured that criminal activity is being contained or reduced, right? And so the goal here, according to William Barr, is incapacitation through incarceration. Here, we don't care about the rights of the accused nearly as much. What we're trying to do is stop crime from happening. If the police break into somebody's house without a warrant, search it, and find out that they have a lot of criminal paraphernalia in the house or something, who cares if there wasn't a warrant? They shouldn't have been doing something bad in the first place, right? And so we need to punish them for it because they've done something wrong. Now, an example of this crime control model is California's 3 strikes law, right? This is criminals get convicted of a third felony. Once criminals are convicted of a third felony, no matter how minor, they must be sentenced to either 25 years to life or triple the regular sentence for that felony. Right? And so it doesn't matter what crime you've committed. You could, there's famous examples of someone who, stole pizza out of a Domino's delivery car. And that was their third felony. And so they got sent to prison for the rest of their life, right? They're controlling crime. The rights of the individual are largely unimportant, right? And so we have these conflicting goals, and we have these different models as far as the rights of the individual versus the rights of the accused. Now, the second discussion question you guys are going to have to answer over the course of this semester is this one. Should a man who robs a store to pay for needed medicine be punished the same as a man who robs a store to pay for recreational drugs? Right? Now, some people here say the motive matters, right? Someone who's robbing a convenience store to pay for medicine they can't afford is trying to do something for to better themselves, whereas someone who's trying to pay for recreational drugs, maybe not, right? But basically what this conversation comes down to is equality versus discretion, right? Equality basically means that it's the same consequences for all people who commit the same crime, right? And so there's this principle of proportionality and equality. The punishment should be consistently related to the magnitude of the offense. It doesn't matter why a person is dead on the side of the road, you killed someone. Whether it's because they were running out in traffic and you ran them over with your car, or it's because you plotted out a murder, murder is murder. Robbery is robbery. Drug use is drug use. It doesn't matter. There's no good reason to commit any of those crimes, and so whatever happens to you, you need to get the same punishment. The facts don't matter. Discretion, on the other hand, is actually kind of the opposite of that, right? This is the use of judgments about the circumstances of certain offenses that lead to appropriate variations in how the system responds to those offenses, right? This, with discretion, we care about the motive. If you are speeding down the road because you're drag racing, should you get the same punishment as if you're speeding down the road because your wife is about to give birth in your car and you're trying to get her to the hospital? According to discretion, well, no, the police should probably help the wife get to the hospital who is trying to have a baby, right? But with discretion, it does lead to sentencing disparity. And this is the tendency for judges to administer a variety of penalties for the same crime. And this has caused some problems for some people, right? Some people have this idea of, I committed the same crime as, so-and-so down the street. Why am I getting 10 years and he's getting, 5 months? And specifically, this has been seen in sentencing disparities and race. And there's a lot of research on race and capital punishment that actually shows that if you are a black man who kills a white woman, you are significantly more likely to get the death penalty than if you are if the offender-victim demographics are anything else. Black people who kill white women get sentenced to death the most. And so again, this discussion question is going to ask you guys, basically, are you more in favor of equality or discretion? Now, a third discussion question you guys are going to have to answer is this. What is the goal of a trial? Now, a lot of times people will say, to find out if someone's guilty or innocent, or to find out the truth, or maybe to solve a conflict. Right? There's a lot of different ways that people can answer this question, right? And so the real conflicting goal here is, are we trying to discover the truth, or are we trying to resolve conflicts? The basic assumption is that the trial is a truth-finding mechanism, right? And we assume the trial is a very rational event. It assumes the truth can be ascertained, that a clash between two opposing sides will actually get at the truth, and it also assumes a lot of accuracy of the facts presented. Are all of these assumptions actually true, though? Some would argue no. As a matter of fact, they're not all that true. And in fact, you'll discover as this course goes on that there's a huge difference between a legal truth and a factual truth, between legal guilt and factual guilt. Those things are not the same thing, and oftentimes, in fact, are opposite of each other. So if the trial's not a rational event, then what is it? Well, the trial could be a test of credibility, right? Maybe we're trying to see who's the most credible. What side is the most credible? Not only are we hearing both sides, but we evaluate, the jury at least evaluates the accuracy and credibility of the evidence being presented. And so there's more emphasis here on weighing facts differently. And it assumes, though still, with credibility, that we can weigh facts well. We actually know from social science research that attractive witnesses tend to be believed more, that witnesses who are less nervous tend to be believed more and are viewed as more credible, and those things might not actually be in any way related to accuracy. So maybe the trial as a test of credibility maybe isn't all that fair also. So if it's not a test of credibility, then what is it a test of, right? Maybe it's a conflict resolving ritual, right? And a ritual is a term that's probably making some of us uncomfortable. Because it is a ritual kind of suggests that it's maybe a little too uniform and the outcome is maybe a little too predictable. But some people argue that it really just creates a sense that justice is done. Some argue that the trial becomes less about discovering the actual truth and more about just resolving the conflict. All right. Trayvon Martin was shot by George Zimmerman. George Zimmerman was found not guilty. We gave it our good shot. And justice was served in that case in the sense that, George Zimmerman got tried, but he wasn't convicted. But oh well, at least we went through the process, right? And that process is important, and we call that procedural justice, right? And this is fairness in the process of administering the law and resolving disputes. The outcome isn't nearly as important as the process or the procedure being fair. Now, that probably makes some of you uncomfortable as well. And the truth of the matter is, I understand that, but that is more of the resolving conflict side of this, right? And in large part, the reason why this process matters is because of the way our system is set up. Our adversarial system forces jurors to choose between competing versions of the truth, right? Both sides of a dispute get to stand up and say their side of the story. Kind of like if any of you had conflicts with your brothers and sisters growing up, your parents probably said to you guys, both of you, tell me what happened, and then you try and solve the problem, and the truth is somewhere in the middle. So, are conflict resolution and truth actually compatible? Some have argued that the primary purpose of trials is really not to get at the truth, but rather that they're simply rituals that give society the feeling that conflicts are being resolved in a nonviolent way. And there's this kind of illusion of fairness. And the truth of the matter is that truth is probably very much unknowable. Will we ever know for certainty what happened that night George Zimmerman and Trayvon Martin met up with each other? Probably not, right? That truth is probably unknowable. Now, we're going to switch gears a little bit to the readings. And I'm posting your readings on Canvas for what you'll be expected to read for Exam 1 and for Exam 2. And as you watch these lectures and stuff, just make sure you're doing the readings that correlate with each lecture. Some comments on the book, though. Remember, this book is not the last word on the law by any stretch of the imagination. In fact, it's designed to raise questions and leave many topics open-ended, which is exactly what this course is supposed to do. If you notice, I didn't tell you what the goal of a trial was. I didn't tell you if it's better that 10 guilty people go free or one person suffer. I didn't suggest whether or not the motive matters and equality is better than discretion. It's up to you to decide which of those things is more important to you, right? I want this course to inspire you to think for yourself, and I want the book to inspire you to think for yourself. It's supposed to be provocative. The readings are sometimes a little tough to get through. They're a little dense. Hopefully, we can work through them together, right? Instead of being a book in law, also, for those of you who want to go to law school, this is not going to be anything like a book that you have will get assigned to you in law school, or even probably texts you've had for a law minor if any of you are in it. It's a book about the law. So instead of what does the law say, this says why does the law say what it says? What are some reasons why the law says what it says? Right? And so we're going to start with actually the foreword of the book. And we've read a bunch of stuff by Kafka in this foreword, right? Studying the law. How does Kafka's parable Before the Law illustrate the problems that you may run into in studying the law? What is Kafka trying to tell you about the law, right? The foreword was very, very dense and not necessarily very easy to get through, right? The parable is confusing, it's convoluted, and we're reading here about this doorkeeper, and you can't figure out, it's like, golly, this guy has waited his whole life to gain access to the law, but then he doesn't actually ever get access to the law, and then when he dies, the doorkeeper says, hey, you could have come through here at any time, but the whole time the doorkeeper wasn't letting him come in. What does it all mean? What effect does this parable have on you? Are you frustrated? Are you angry? Are you disturbed? It really does evoke, when you're reading this, a lot of emotion, because you're sitting there thinking, wait a minute, what does all this mean? Do I actually have access to the law or not? Now, in part of the foreword, you read a dialogue between the priest and Kay. And Kay's basic argument comes down to the idea that justice was actually denied the man from the country. In your judgment, in your opinion, is that true? Was justice denied? The man was supposed to have access to the law the whole time. And in fact, a quote from the book is, right before he dies, he said, no one could gain admittance through this door, since the door was intended only for you. I am now going to shut it. This door wasn't meant for anyone but you. You came here, you waited your whole life, you gave up all of your resources, all of your time, your whole livelihood to gain access to something that was meant and built specifically for you, and yet you never actually gained access to it. What character did you really identify with the most? Did you feel like you were the man from the country, the doorkeeper? Are you the priest? Are you Kay? And what social roles and positions are represented by these? Some people argue that maybe the priest is like a law professor or a judge, that maybe Kay is like a law student. The doorkeeper might be these structural things in society that keep us out from the law, that the man from the country is really anybody who lives there. There's a lot of things that people suggest about these positions that are relevant to the law. And it's super hard and super difficult to try and figure out what are all these people. Sometimes you might feel like the man from the country. Sometimes you might feel like Kay. When you talk about the law with your parents, maybe sometimes you're more like the priest. If you decide to go into law enforcement or become a lawyer, depending on your role, maybe you're like a doorkeeper. It's very unclear what all of these mean, but maybe we could be little pieces of all of these characters in this foreword. Now, one of the quotes from the foreword is that the problem of our law is that it's not known to us. It's created by a small group of nobles who rule us, right? And so Kafka says, we are more inclined to hate ourselves because we have not yet shown ourselves worthy of being entrusted with the law. Now, that suggests a lot of different things. Is the problem really with the law? Is it with the people that enforce the laws? Is it with the institutions that enforce the laws? Why are we more inclined to hate ourselves? Why is it that we've not shown ourselves worthy yet to be entrusted with the law? Do you think that the problem is maybe not structural, but maybe the problem's with the man from the country? Maybe the man from the country should have, instead of laying around and selling all his possessions and trying to give everything away to the doorkeeper, maybe he should try to fight the doorkeeper, even though the doorkeeper was ferocious, and tried to work his way into the law. Maybe it's the doorkeeper's problem. The doorkeeper's, just another person. He just happens to be working for the law and is influenced by the law. Maybe the doorkeeper should have helped the man from the country more. Maybe it's a combination of the two. Maybe the man from the country and the doorkeeper should have discussed and debated and worked together to become more entrenched in the law. That's, again, stuff that you have to decide for yourself. Now, if we move on to the last part of the foreword, F.4, there's this very short reading in this very short paragraph about kings versus couriers. And it says that we're offered the choice between becoming kings or couriers of kings. The way children would, they all wanted to be couriers. Therefore, there are only couriers who hurry about the world shouting to each other. Since there are no kings, messages have become meaningless. They would like to put an end to the miserable life of theirs, but they dare not because of their oath of service. So why would people choose to become couriers instead of kings? What is the point of a courier? The job of a courier is just carry the messages of the kings. Why is everyone so excited to be a courier instead of a king? Some people argue that people want to be, the face of the king, right? I would rather be the one out in public that everyone sees and says, oh, he works for the king, instead of actually being a king himself. The problem is if everyone is out there being couriers and there are no kings, where are the messages that the couriers are carrying coming from? They're not coming from anybody, right? And so they become meaningless because there's a bunch of people theorizing about law, but no one actually doing law, or vice versa, right? And so it suggests that we need strong leadership in the law, as well as strong people to carry out the law. And again, all of these readings, you should finish this forward, and I suspect that what's going to happen is after you read through this forward, I'm going to get 1,000 emails saying, I don't get it, I don't get it, I don't get it. And that's correct. Because guess what? I don't get it, right? Every time I think I have these squared away, I think of another angle with which it could mean something. And that's the point of these little parables that you've read, is the law is that complex. As soon as you think you've got it figured out, something changes that throws it all on its head. And we'll learn throughout the course of the semester that that's how the law works. It's how the law functions. Just when we think we know what's going on is right when something changes to flip us on our heads and prove that we don't know actually what's happening. Now, again, after this lecture, you should be able to do some of these discussions. And really, discussions don't need to be based in actual fact. You don't need to cite anything. I want these discussion questions that you ask to be more opinion-based. Tell me how you feel about these discussions. Tell me what your opinion is on these topics, right? And when you respond to a classmate, don't just respond to someone and say, okay, sounds good. Respond to someone and say, this is why I believe what I believe. This is how I believe what I believe. And really work through this in the discussion. You'll see me in the discussion posting comments as well. Feel free to challenge me on my ideas as I challenge you as well. All right? Thank you all so much, and I'll be back soon.